In November 2019, Adaro filed a class action in the Sydney Registry of the Federal Court. We did this on behalf of Cameron Baker and approximately 7,000 current, former salaried employees of Woolworths. The affected workers have instructed Adaro that they have suffered underpayments and systemic wage theft during their employment at Woolworths. This action covers individuals who are not EBA covered or were not paid based on the actual hours they worked. These people were called salary workers and were typically performing managerial and supervisory roles within the Woolworths group. That they performed additional hours that they did not record on their Kronos or site attendance system. They were required to work shifts, including night shifts, that they did not receive allowances for or meal breaks for. People have asked why this action should be started now, rather than waiting for Woolworths to make their voluntary underpayments to the workers. We take the view that it is dangerous to make limitation periods and other damages sit on the sideline whilst an employer conducts their own, perhaps self-interested, paid audit. In simple terms, without this action, there is no mechanism to resolve how the dollar value of any underpayment will be calculated and how that underpayment will achieve a just outcome for you. No. We encourage Woolworths to take every step it can to repay the $300 million that it has volunteered was rightfully not paid to its workers. This class action will not stop Woolworths making payments to affected workers. It will actually assist workers to get higher payments and to actually be paid for every hour they in fact worked. Separately, Woolworths will also be required to pay penalties for its contravention of Australian law. An individual penalty can be up to $52,000 per contravention or worker and have historically never been paid to workers that were wronged. Such payments were only ever made to the Commonwealth in a similar vein to a speeding ticket. Our action will ask the court that these penalties go to the workers that have been shortchanged for over 6 years. Employers have told us that they may need to sign a deed of release to receive their back pay. You should know that there is no legal requirement for you to give up your legal rights to simply receive the minimum rates of pay that you are entitled to. If you are asked to sign a deed of release, we ask that you immediately contact us and indicate to your managers that you are seeking legal advice on this issue. A deed of release is only appropriate where there is money being paid to resolve a genuine dispute. If all that Woolworths is doing is paying the legal minimum rate of pay, then there should be no request for any deed, and you should say no. This class action will run on a no-win, no-fee basis. We will not charge you any money if we are unsuccessful in the claim, and we will not try to deduct money from any underpayments that Woolworths will voluntarily pay to you before Christmas or before mid-next year. We are going to ask the court to only remunerate us in reference to the legal work that we do to resolve payments that Woolworths disputes and to the penalties that should be paid to you. In simple terms, our fees will come from additional payments to you beyond what Woolworths has volunteered to make now. We have received numerous requests from current and former Woolworths staff inquiring as to whether they are eligible to join the class action. We invite current and former salaried staff members to register their interest on our website, and one of our team will be in contact with them shortly.